Are you paying alimony and your ex is now remarried or living with somebody else? I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today I'm going to explain how remarriage or cohabitation by the person receiving alimony can impact your obligation. Now, first off, in Connecticut, alimony does not automatically terminate by statute if the recipient who is receiving alimony remarries. Now, with that said, almost all divorce judgments, particularly if there were lawyers involved or if the case went to trial and the judge is issuing orders, in those situations, the divorce judgment will almost always say that alimony terminates upon the remarriage of the recipient. That's just generally negotiated by the lawyers, and it is how divorce agreements are drafted. Now, with that said, particularly if there are self-represented parties involved, they may not incorporate that language into the judgment. So in that scenario, alimony will not automatically terminate upon remarriage. However, it can be a basis for modification. In order to modify alimony, you have to show that there has been a substantial change in circumstances. So if the person receiving alimony's circumstances have changed based on their remarriage, then you might be able to modify alimony. Remarriage can reduce healthcare premiums, they can result in better tax treatment, and those scenarios can increase the net income of the person receiving alimony even if their gross income has not changed. Or they may receive financial support from a wealthy spouse, for example, or just living with that person can reduce their expenses, which gets into cohabitation. But generally speaking, because of tax treatment and healthcare benefits, the financial circumstances of somebody will improve based on remarriage, so that can be a basis to modify alimony. Now, to get into cohabitation, that can be a little bit more tricky as far as what happens to alimony. Cohabitation does not automatically terminate alimony unless, of course, in a divorce agreement says that it does, which normally it will not. Instead, the statute of Connecticut General Statute Section 46B-86 subsection B, that statute governs cohabitation and how it impacts alimony. And specifically, it says the court may, in its discretion, modify alimony and suspend, reduce, or terminate the payment of periodic alimony upon a showing that the party receiving the periodic alimony is living with another person, and it must be under circumstances which the court finds should result in the modification, suspension, reduction, or termination of alimony because the living arrangements cause such a change in circumstances as to alter the financial needs of that party. So it's important to show that the new living arrangement essentially reduces the expenses of the person receiving alimony based on the fact that they are living with somebody else. So presumably that may be a new spouse or significant other who is contributing towards rent, or it could be just a roommate who's contributing towards rent. And again, it does not necessarily terminate alimony. Instead, the court can reduce or suspend alimony, or they do have the option to terminate alimony. So generally speaking, you need to file a motion to modify alimony if there is cohabitation or remarriage, unless the agreement is clear that remarriage terminates alimony, in which case you don't have to file a motion to modify, you can just stop making alimony payments.